case briefs, and so much more. LSData's got what you're looking for.
In the 1940 Illinois Appellate Court case, Commonwealth Building Corp v. Hirschfield, a landlord and tenant became embroiled in a dispute over rent. The tenant's lease expired on September 30th, but they were still in the process of moving out, with some belongings remaining on the property. The landlord accused the tenant of holding over and demanded payment for October's rent, citing a lease clause that mandated double rent if the tenant stayed past the lease's expiration. In the 2 months leading up to the lease expiration, the tenant had informed the landlord of their intention to move out and hired a moving company to assist with the process. Over the course of 3 days, the tenant's belongings were gradually removed from the property. The court was tasked with determining if the tenant could be considered a trespasser or if they were still technically a tenant who owed rent for the additional time. In their decision, the court ruled that the defendant was not liable for October's rent, as the plaintiff failed to prove that the defendant had held over or agreed to extend the lease. As a result, judgment was entered in favor of the defendant, the verdict was set aside, and the order for a new trial was reversed under Civil Practice Act Section 92.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.